Welcome everyone to the On the Docket podcast, the podcast concerning all things Supreme Court. For the very first episode, I tried to pick out a good one, and I think I did. This is a fresh case, hot off the presses, and it began in 2018 and ended in 2019. Today we're going to be talking about everybody's favorite non-controversial topic, the death penalty. Is it cruel and unusual, perhaps so much so that it violates our Eighth Amendment rights? Or, as others argue, do the criminals on death row deserve their fate? Well, the case we're going to be talking about today asks all those questions and more. Enter Bucklew v. Precythe. First, let's add some context. Russell Bucklew is in a relationship with a woman named Stephanie Ray. The two had lived together in a mobile home in Missouri, but things ended when Stephanie broke up with Bucklew on Valentine's Day, a result of which was Bucklew moving back in with his parents. Things then took a turn for the violent when on March 6th, Bucklew broke into the mobile home he had shared with Stephanie. Inside, he found another man named Michael Sanders, who he assumed was Stephanie's new significant other. Bucklew held a knife up to Sanders' throat and threatened to kill Sanders if he ever returned. Bucklew then presumably fled the scene. He returned later that day, however, to find Stephanie alone in her mobile home. He threatened her, cut her, and punched her before once again fleeing. Stephanie Ray reported this incident and the threat against Michael to the police. Unfortunately, Bucklew was tenacious. He called Stephanie at work the next day and threatened to kill her and her children if he ever spotted her with Michael Sanders again. Ray decided to move in with Sanders because she no longer felt safe in her mobile home. Between the night of March 20th or the 21st, reports conflict on that part, Bucklew stole his nephew's car, 2 of his brother's pistols, 2 sets of his brother's handcuffs, and a roll of duct tape. He also left a note for his family requesting that they not report his theft. On March 21st, Bucklew began secretly following Stephanie Ray. Over the course of the day, he learned that she had moved in with Michael Sanders. Bucklew knocked on the door to Michael Sanders' mobile home, and one of Sanders' children answered. Sanders himself saw Bucklew through a window and escorted the rest of his kids into a bedroom before grabbing a shotgun. Sanders, shotgun at the ready, greeted Bucklew in the hallway. Bucklew warned, "Get down," before firing at Sanders with his 2 stolen pistols, hitting him twice. 1 bullet entered and exited Sanders' lungs. He dropped his shotgun in the folly of it all. Bucklew aimed his stolen weapon at Sanders' head, but when he caught sight of Sanders' 6-year-old son, Bucklew decided to shoot the boy instead. Thankfully he missed. Stephanie Ray stepped between Bucklew and Sanders, who was clutching his chest wound. Bucklew demanded that Ray drop to her knees. When she did not comply, Bucklew pistol-whipped and handcuffed her, dragging her into his car and driving off. He took her to an unnamed location where he demanded sex. When she refused, Bucklew raped her. After his vile act, he got back on Interstate 55, where he was apprehended by the police after a gunfight in which he, Stephanie, and 1 officer were wounded. Unfortunately, Michael Sanders died of blood loss. In trial court, Bucklew was charged and found guilty of first-degree murder, kidnapping, and first-degree burglary. His sentence? Death. Bucklew appealed directly to the Missouri Supreme Court on many other grounds, but none of them included the cruelty of the death penalty. The Missouri Supreme Court upheld the lower court on a plethora of points of Missouri state law, which I'm not going to get to. Just the main idea is that Bucklew's death sentence was upheld. Although the crimes were originally committed in 1996, all of these legal processes ended in 2006. And starting in 2006 and ending in 2010, Missouri followed a number of other states in reforming death penalty procedures. Before these reforms, Missouri executed its death row inmates via lethal gas exposure. Beginning in 2006, however, the prisons switched to using lethal injections instead. While the reforms were taking place, scheduled executions such as Bucklew's were postponed while the prisons gathered the supplies needed and trained the people who would be administering the injection. Their first execution process using lethal injection was a 3-step injection process, and one of the drugs used in this injection process was sodium thiopental, which is a barbiturate notorious for being used as part of lethal injections and other euthanasia processes. It's injected intravenously in sometimes large doses to ensure that the patient is unconscious when they receive the lethal drug, the one that's supposed to kill them. The pharmaceutical company that distributed this drug to Missouri prisons experienced several difficulties, such as anti-death penalty advocates and limited supplies. These resulted in Missouri prisons switching from a 3-step execution process to a 1-step execution process, which only used propofol before switching to pentobarbital. The reason for the switch from propofol to pentobarbital is that propofol is largely manufactured in Europe, and the European Union threatened to halt all exports of propofol to America if it was used for executions. Pentobarbital works similarly to the other two drugs, but in large doses it causes breathing to stop, killing the patient. During all of these execution method switches and reforms, Bucklew's executions kept getting postponed again and again. Finally, after Missouri settled on using pentobarbital, Bucklew filed a lawsuit in federal district court against Ann Precythe, the Missouri director of the Department of Corrections, hence the name Bucklew v. Precythe. Bucklew argued that a condition he was born with, a cavernous hemangioma, would render the pentobarbital execution cruel and unusual. A cavernous hemangioma is a genetic disease where the person who has it has a malformation of the blood vessels that results in slow blood flow through bodily cavities. Bucklew claimed that because of his disease, the pentobarbital would circulate through his lungs slowly, giving him excruciating pain and a feeling of suffocating and drowning, which he said violated his Eighth Amendment right. He also claimed that instead of lethal injection, he should be executed via nitrogen hypoxia, as that was less cruel in his arguments. Essentially, with this method, Bucklew's lungs would be pumped full of nitrogen until he suffocated and died. Additionally, Bucklew requested a new period of discovering, which is finding evidence for a lawsuit. He requested this new period of discovery to look into the qualifications of the people overseeing his execution. In their ruling, the federal district court granted summary judgment to the state. Summary judgment is a ruling made by a court without a trial or a jury. I know this sounds like a breach of Constitution, but just bear with me for a moment and I'll see if I can explain it. Summary judgment is granted when the important facts of the case are undisputed by both parties and it is clear that one party is in the right and the other is in the wrong. When summary judgment is granted, the judge is saying that in their opinion, the case is so clear-cut and a winner is so obvious that using a jury to decide would be a waste of time. Whoever summary judgment is granted to is essentially the victor of the case. In this instance, the federal district court granted summary judgment to Ann Precythe and the state of Missouri as a whole. This means that the important facts of Bucklew's case, his disease, Missouri's method of executions, and all that, were undisputed by both Bucklew and Missouri. On top of this, the federal district judge, in whichever district Bucklew filed the lawsuit, felt so confidently that the state was clearly in the right, they felt that a trial would be inefficient and decided instead to write a statement upholding the state's arguments and therefore upholding Bucklew's execution. On Bucklew's second point, the federal district court found that Bucklew had not aptly described how execution via nitrogen hypoxia would be less painful than pentobarbital. The federal district court further denied Bucklew's request for additional discovery, stating that it would be inappropriate to suggest that Missouri employs people who are unfit to do their job. So essentially, the federal district court kind of just spits in Bucklew's face and says, get out of here, and denies him all three of his objections. Bucklew, however, is undeterred. He still has two more courts to appeal to, the U.S. Court of Appeals, aka Circuit Court, and the big boss himself, the U.S. Supreme Court. Bucklew appeals to the Eighth Circuit Court of Appeals. The Eighth Circuit Court reviews the district court's decision de novo. A trial de novo is different from a normal appellate trial because in a normal appellate trial, it is assumed that the facts of the case and the evidence submitted to the court are all true. So the court with appellate jurisdiction, which is the court hearing the case on appeal, doesn't determine the facts of the case, nor do they examine evidence. Instead, they determine whether any legal procedure was violated during evidence collection or during the trial. An example of this is if John Doe sues Jane Smith and John Doe wins, but Jane appeals to the appellate courts, either state or federal, depending on which type of court the original case is heard. And she says that the jury for her trial was biased. In this case, the appellate court is not going to re-examine the facts of the original suit, nor are they going to re-examine the evidence submitted to the court in the original trial. Instead, they would only seek to find out whether or not the jury was biased in the original trial. This differs from a trial de novo, however, because a trial de novo is a case on appeal in which new evidence may be submitted. Federal appellate courts usually hold trials de novo when the lower court has made some sort of constitutionally important decision. So in this case, when Bucklew appealed to the U.S. Court of Appeals in the Eighth Circuit, they saw that the federal district court had ruled on an Eighth Amendment case, whether or not the death penalty constituted cruel or unusual punishment, And they said, whoa there, this is an important case, this is an important decision being made here. We want to take this case and double check the federal district judge's decision. So then the judges in the 8th Circuit Court of Appeals would carefully read through the trial record, evidence, the judge's decision, and most likely precedent as well. And from there, they would determine whether they should uphold or overturn the federal district judge's decision. In this case, the Court of Appeals went through all that procedure, and in the end, they upheld every decision made by the federal district judge. They agreed that Missouri's method of execution using pentobarbital did not violate the Eighth Amendment. They agreed that Bucklew had not shown in detail how a nitrogen hypoxia execution would be less cruel, and they agreed that there should be no investigation into the qualifications of the personnel administering the pentobarbital. Twice defeated but never deterred, Bucklew appeals his case to the U.S. Supreme Court, the most powerful legal arbiters in the United States. When he brought his case to the Supreme Court, there were multiple constitutional questions being asked. The first two were questions about Missouri's method of execution and how they were affected by the Eighth Amendment. Bucklew brought both an as-applied and a facial challenge to Missouri's method of execution. An as-applied challenge means he's saying the pentobarbital execution violates the Eighth Amendment as applied strictly to Russell Bucklew due to his rare cavernous hemangioma. A facial challenge means that Bucklew is also asking the court to decide on whether or not the pentobarbital execution violates the Eighth Amendment when applied to any given death row inmate, not just Bucklew. There are 4 other constitutional questions being asked as well. First, what evidence is required for a court to determine whether an inmate's proposed alternative method of execution significantly reduces the risk of severe pain as compared to the state's method? The second, may a court evaluating a challenge to a state's method of execution assume that medical personnel on the execution team are qualified? The third, does the Eighth Amendment require an inmate with a unique and severe medical condition to prove an adequate alternative method of execution when challenging the state-authorized method of execution? And the fourth, did the petitioner meet his burden in proposing an alternative execution method under Glossop v. Gross, which is a precedent Supreme Court case that dealt with this idea as well. So before we get into the actual decision of the court, I just want to explain some things and introduce the justices to provide context and make sure that we're all on the same page. For starters, the excerpt of the Constitution that is in question in this case is the Eighth Amendment, which reads, "Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted." And the last part of the sentence, the "nor cruel and unusual punishments inflicted" part, is really what's important here. So, keeping that idea in mind, let's introduce the justices. The Chief Justice, the big boss of the whole joint, is John Roberts. John Roberts was nominated in 2005 by George W. Bush to replace retiring Justice Sandra Day O'Connor. But when Chief Justice Rehnquist died just a few months later, Bush withdrew Roberts' nomination to replace O'Connor and re-nominated him as the Chief Justice. So this is a Roberts court case, keep that in mind. During his testimony before the Senate, Roberts stated that he thought it would be inappropriate to enter the Supreme Court with an unchangeable legal philosophy. Essentially, he was saying that he's going to decide on cases on kind of a case-by-case basis, not on his personal philosophy. He also demonstrated a vast knowledge of Supreme Court precedent. He was approved by all Republican senators and half of the Democratic senators, making him the Chief Justice. Roberts tends to land on the conservative side of the spectrum, but has on numerous occasions sided with liberal justices. He has also been a deciding factor in a multitude of cases. Regarding the death penalty, he has most often sided with it, with the exception of a few cases. Next, we have Associate Justice Clarence Thomas. Thomas was another Bush nominee who was nominated after the retirement of Thurgood Marshall. Thomas was confirmed after a very narrow 52-48 vote in 1991. In cases regarding the Eighth Amendment, Thomas has often supported giving the states broad powers to determine their execution method. Something else that is important to note is that Clarence has been remarkably fearless about being a lone dissenter in many cases during his time on the court. Next on the roster is Associate Justice Ruth Bader Ginsburg, the infamous RBG. Ginsburg was a Clinton nominee in 1993 meant to replace Justice Byron White. During her confirmation hearing, she refused to answer any questions regarding the death penalty. At the time of her nomination, she was seen as a moderate, and was confirmed in a 96-3 vote. in 1993. On the court, she moves cautiously and meticulously, working to strengthen precedent instead of exercising judicial activism. Since she started serving on the court, Ginsburg has been viewed as the leader of the liberal-leaning justices and often authors the dissenting opinion. Next up, Associate Justice Stephen Breyer. He was a 1994 Clinton nominee to replace Justice Harry Blackmun. He was confirmed to the court in 1994 by an 87-9 vote in the Senate. Breyer has proven to be more of a judicial activist, considering the deeper consequences to a piece of legislation or a section of the Constitution, rather than just extrapolating it at face value. Breyer has tended to fall slightly on the liberal side of the court. Going down the line, we have Associate Justice Samuel Alito. Bush nominated Alito in 2005 to replace retiring Justice Sandra Day O'Connor. Despite being given a well-qualified rating by the American Bar Association, Alito was torn a new one at his confirmation hearing. This is due to the fact that he had some ties with conservative groups, and despite him expressing a desire to be impartial on the court, Democrats grilled him and attempted to make him look intensely conservative, while the Republicans attempted to lessen the hardcore conservative persona. Nevertheless, he was confirmed to the court by a 58-42 vote. Today, Alito is recognized as being one of the most staunchly conservative justices on the present court. Next, there's Associate Justice Sonia Sotomayor. She was nominated in 2009 by Barack Obama to replace the soon-to-retire Justice David Souter. Sotomayor's confirmation was marred by Republicans pointing to her voting record on lower courts and creating fear-inspiring rhetoric that she was just another liberal who wanted to take away all the guns and give certain races of people advantages over others. She quickly denounced these claims and was confirmed by a 68-31 vote in 2009. Throughout her justiceship, she has become known as a beacon of support to the rights of accused persons and a criminal justice reform enthusiast, including the death penalty. She too tends to fall on the liberal side of the spectrum in her decisions. In 2010, Obama nominated the next Associate Justice on the list, Elena Kagan. Despite being considered moderate to liberal, her nomination concerned some Democrats because she was meant to replace retiring Justice John Stevens, who was more liberal than her. This meant that if she were to be confirmed, she could potentially dilute the strength of the liberal side of the court. Nevertheless, her confirmation process was filled with praise from both sides, as she was seen as someone who could convince people to get on her side and someone with a deep understanding of the law. In 2010, she was sent to the court on a 63-37 vote. Since her confirmation, she has found herself amongst the company of the other liberal justices of the court. Next up, the Spitfire from 2017. It's none other than Neil Gorsuch himself. In 2017, Trump nominated Gorsuch to replace the deceased Justice Antonin Scalia. In such a politically charged time, it's no surprise that Gorsuch's confirmation vote went straight down party lines and ended in a 54-45 vote of approval. Gorsuch is still fresh to the court, but he tends to fall on the moderate to conservative bloc of justices. Regarding the death penalty, Gorsuch has generally supported it, but has been careful to consider the pain inflicted by the death penalty. And last but not least is the newest addition to the court, Associate Justice Brett Kavanaugh. Kavanaugh was a 2018 Trump nominee to replace Justice Anthony Kennedy. Kavanaugh has been speculated to fall on the conservative side of the court somewhere between Gorsuch and Alito, so his nomination had the potential to shift the court ideologically to the right. His nomination, as with Gorsuch's, was riddled with controversy and finger-pointing from both sides of the aisle, and as with Gorsuch, Kavanaugh's confirmation vote went directly down party lines, and he was confirmed in a 50-48 vote. Now that the justices have been introduced, let's get into the highlights of the oral arguments. Right off the bat, in Bucklew's lawyer's opening arguments, he clarifies what he means when he says that the medical personnel of the Missouri execution team are not qualified to do their job. To be honest with you, reading through this case, every time they mention the qualifications of the execution team, I thought it was a silly, unnecessary tangent, but as it turns out, what Bucklew meant was that the Missouri executioners had not been informed of Bucklew's cavernous hemangioma, and thus would not be prepared to deal with it accordingly. Afterwards, Sotomayor absolutely grills Bucklew's lawyer on whether or not the pentobarbital would cause him to choke on his own blood and how long it would actually take to circulate through his system. Then, Bucklew's lawyer has his back against the wall as he's answering quick-fire questions from Alito, John Roberts, and Sotomayor all at the same time. The thing they're mainly arguing over is how long it's going to take for the pentobarbital to course through Bucklew. Here's a quick excerpt from when they're talking about what Bucklew's execution would look like. At this point in the argument, there is a back and forth about whether the executioner is a board-certified anesthesiologist and whether or not they will be able to gain access to Bucklew's femoral vein to inject the pentobarbital. So Bucklew's lawyer is Robert Hockman, and he says, yes, because the board-certified anesthesiologist that I'm referring to, who previously accessed the femoral vein via cut-down, is the same person who's going to do Mr. Bucklew's execution, unless they haven't changed and haven't told us. It's the same person. And what Dr. Antignini, who's a witness, said, he said, everyone who's board-certified is trained to access the femoral vein. But when asked point-blank, does everyone have experience doing it, he said no. He said you can go decades without doing it at all, and you could lose the ability to do it. And the cut down, the testimony can take 15 minutes and maybe more, and it's carving into his leg. So let's paint the whole picture here. He is lying flat, they're carving into his leg, causing a tremendous amount of stress. It's the worst possible set of circumstances. There's little doubt in my mind if he doesn't have a trach, he would be suffering enormously. Suffocating, having difficulty breathing, and this is not a short period of time. So then Sotomayor says, is there another alternative to the cut down to access the femoral vein? Hockman says he hasn't had a chance to talk with the Missouri execution team. Sotomayor asks if there are any alternatives to accessing the femoral vein. Hockman says, I believe there are, Your Honor. I believe that some people who are skilled and have a lot of experience with this can, just do it. Sort of visualize where the femoral vein is and effectively do it. The best way to do it is you bring an ultrasound in. There's no suggestion that there will be an ultrasound in this case, but I want to emphasize that what the record shows is when they start this process, they're not going to be aware of the breathing issues. They got a one-page summary of Bucklew's condition. It mentioned that he has cavernous hemangioma on the face and lip. It didn't mention the tumor in his throat. It did not indicate any breathing issues. Nothing in the record indicates they would check Mr. Bucklew's airway. Nothing in the record indicates they normally, in the normal course, would monitor an inmate's respiration. Nothing in the record suggests they would have the equipment present in the room to deal with an airway collapse while he's on the table waiting for the drug to be infused, which is a very long period of time. And as I was about to say before, you'll see how far in advance of the time they administer the lethal drug that they begin the efforts to gain venous access. He's lying flat that entire time. He struggled through a cut-down procedure. He's probably bleeding from his tumor. The risk of an airway collapse is very high, and there's nothing in the room to deal with it. Later on, Chief Justice Robert brings up the point that Hockman is arguing that pentobarbital is cruel and unusual, but at the same time he's arguing for a nitrogen hypoxia execution, which is a method that has never been used in any other state and which may be even more painful for Bucklew. John Roberts then drives his point home by mentioning the precedents set in the cases Bays v. Rees and Glossop v. Gross, in which the court ruled that the Eighth Amendment prevents any unnecessary infliction of pain, not any infliction of pain. He then reiterates that Hockman is advocating for a method never before used by any state, so nobody knows what kind of pain nitrogen hypoxia will cause. After Hockman's grilling, it's time for Missouri's attorney, D. John Sauer, to step up to the plate, and his opening arguments don't fare any better. He's in the middle of pointing out that Missouri has executed 20 people using pentobarbital without any significant incident when Sotomayor interrupts him and asks him how many of those inmates had Bucklew's condition. Sauer is forced into admitting that the number is 0. Here are some highlights from Sauer's interaction with the court. Sotomayor asks, so why haven't you represented that you're going to take the basic steps necessary to avoid the horrific circumstances that your adversary says can and will happen? Sauer says, we vigorously dispute that horrific circumstances will arise, but I believe we have made those representations. Sotomayor says, why do you dispute that? Sauer says, because there's every stage of the predictions that are made by the petitioner is contradicted by evidence in the record. Then Breyer says, and the nitrogen, they have a good reason for thinking that the nitrogen won't be painful, that it works in a different way. And yet it isn't quite there in the record, and you can argue it, and that's why there was a dissent in the lower court. So it strikes me as at that point, you should go deal with this as a person rather than a lawyer. Sauer says, I would say two things in response to that, Justice Breyer. First, the state of Missouri has a compelling interest in seeing this just and lawful sentence is carried out as quickly as possible. A remand for further fact-finding, which is the principal request of Bucklew, would interject yet more delay before the execution of a sentence that's been in place for 22 years now. Secondly, the evidence in the record decisively supports an affirmance on either of the two alternative grounds, either of the glossip elements, and I'll address, if I may, the one that you raised, which is the second glossip element, about a feasible, readily implemented alternative solution. Nitrogen hypoxia has never been tried at by any state. At this time, no protocol exists for execution by nitrogen hypoxia. No state has ever tried it. In the controlling opinion in Bayes, this court said 6 times, including twice in the opening 3 paragraphs of that opinion, that an alternative method of execution that is untried and untested, that no state has ever used, that no study supports showing its efficacy, is not an alternative that's reasonable. Kavanaugh then steps in and asks, "Are you saying even if the method creates gruesome and brutal pain, you can still do it because there's no alternative?" Sauer says, "I believe that any petitioner who is claiming that it would create gruesome and brutal pain must, under Bayes and glossip, offer an alternative method that significantly reduces the pain." Kavanaugh asks, "So you're saying that even if the method imposes gruesome, brutal pain, you can still go forward?" Sauer kind of stutters. He says, "Well, I would say that the petitioner has to if they want to." He's interrupted by Kavanaugh, who asks, is that a yes?" Sauer says, "Yes, it is, Your Honor, and that is the holding of glossip." Kavanaugh asks, "Is there any limit on that?" Sauer says, "There is a limit, Your Honor. The limit would occur if the method of execution were viewed as superadding terror, pain, or disgrace within the meaning of the court's earlier method of execution cases. So, if the method of execution was so gruesome and brutal, or was even relevantly similar to the historical gruesome methods of execution that are categorically prohibited by the Eighth Amendment, there would certainly be a claim in that context where, or in the words of Bayes and glossip, there is an attempt to deliberately inflict pain for the sake of pain. That would be categorically exempted. In that context, the alternative method is not required. But if a petitioner claims that, well, I'm predicting that I will suffer under these circumstances, that petitioner must, under the logic of Bayes and glossip, plead and prove an alternative method. After this interaction, Sauer gets into a bit of a verbal fencing match with Justice Breyer. Justice Breyer creates a hypothetical prisoner who has a rare medical condition that makes the lethal injection feel as though he was being burned alive at the stake. Breyer asks Sauer whether or not that would constitute cruel or unusual punishment. Sauer agrees only to the idea that being burned alive at the stake constitutes cruel and unusual punishment. He then draws that idea back to Bucklew, saying that because of his rare medical condition, his execution will feel exactly as if he's being repeatedly drowned to death. Breyer does that, not Sauer. Kavanaugh then says, "Your opposing counsel said, even if everything goes according to plan, there will still be significant suffering. Can you respond to that?" Sauer says, "I absolutely disagree with that. The testimony about this of Dr. Antignini is that the only suffering that would occur in this execution could be medically predicted was the suffering associated with the actual entry of the IV. In other words, the pinpricks or the cut-down procedure. Now I say cut-down procedure, and truth in fact, the record decisively shows that a cut-down procedure is not done in the femoral vein. The only evidence of this is the testimony of Dr. Antignini, who says a cut-down is done on the saphenous, which is much lower down in the leg, in the angle. A cut-down is not done on a femoral vein. The evidence from the warden, who's not a medical person, about the one time a cut-down was done, describes it as being done in the leg. So there's no evidence, and in fact, Dr. Antignini said there is no need to do a cut-down on the femoral vein, because it is easily accessed. And in fact, it is not standard to use an ultrasound in accessing the femoral. So, and the holding of the district court on this points that out as well. Not only has he put in no evidence that there will be any difficulty at all accessing the femoral, but in addition to that, he had presented no argument in opposing summary judgment about any difficulty that would happen on any vein other than the peripheral veins in his arms. So there's really nothing in the summary judgment record that supports the predictions that are being made on. So I want to clarify, they mentioned a cut-down procedure a couple of times. I just want to clarify what that is. A cut-down procedure is when they surgically open up the patient and they move around tissue and stuff like that to surgically access the vein, and then they kind of connect a little tube in the vein. They connect a tube to the vein called the cannula, and then they inject the lethal injection into the cannula, which will funnel into the vein and course through his blood. So now that we've heard some of the oral arguments, let's get into all the different majority, concurring, and dissenting opinions and break those down, because I think those are actually very interesting in their own right. In a 5-4 opinion, the court ultimately ruled in favor of Precythe and the state of Missouri. Neil Gorsuch was tasked with writing the majority opinion, and here's what he had to say. Russell Bucklew concedes that the state of Missouri lawfully convicted him of murder and a variety of other crimes. He acknowledges that the U.S. Constitution permits a sentence of execution for his crimes. He accepts, too, that the state's lethal injection protocol is constitutional in most applications, but because of his unusual medical condition, he contends the protocol is unconstitutional as applied to him. Mr. Bucklew raised this claim for the first time less than 2 weeks before his scheduled execution. He received a stay of execution and 5 years to pursue the argument, but in the end, neither the District Court nor the Eighth Circuit found it supported by law or evidence. Now Mr. Bucklew asks us to overturn those judgments. We can discern no lawful basis for doing so. In 1996, when Stephanie Ray announced that she wanted to end their relationship, Mr. Bucklew grew violent. He cut her jaw, punched her in the face, and threatened her with a knife. Frightened to remain in the home they had shared, Miss Ray sought refuge with her children in Michael Sanders' nearby residence. But then one night, Mr. Bucklew invaded that home. Bearing a pistol in each hand, he shot Mr. Sanders in the chest, fired at Mr. Sanders' 6-year-old son, thankfully he missed, and pistol-whipped Mrs. Ray, this time breaking her jaw. Then Mr. Bucklew handcuffed Miss Ray, drove her to a secluded spot, and raped her at gunpoint. After a trooper spotted Mr. Bucklew, a shootout followed, and he was finally arrested. While all this played out, Mr. Sanders bled to death. As a coda, Mr. Bucklew escaped from jail while awaiting trial and attacked Miss Ray's mother with a hammer before he could be recaptured. After a decade of litigation, Mr. Bucklew was seemingly out of legal options. A jury had convicted him of murder and other crimes and recommended a death sentence, which the court had imposed. His direct appeal had proved unsuccessful in State v. Bucklew, certiorari denied. Separate rounds of state and federal post-conviction proceedings also failed to yield relief, as in Bucklew v. State, where certiorari was denied, and Bucklew v. Lubers, where certiorari was denied. As it turned out, though, Mr. Bucklew's case soon became caught up in a wave of litigation over lethal injection procedures. Like many states, Missouri has periodically sought to improve its administration of the death penalty. Early in the 20th century, the state replaced hanging with the gas chamber. Later in the century, it authorized the use of lethal injection as an alternative to lethal gas. By the time Mr. Bucklew's post-conviction proceedings ended, Missouri's protocol called for lethal injections to be carried out using 3 drugs: sodium thiopental, pancuronium bromide, and potassium chloride. And by that time, too, various inmates were in the process of challenging the constitutionality of the state's protocol and others like it around the country, such as in Taylor v. Crawford. Ultimately, this court answered these legal questions in Bays v. Rees of 2008. Addressing Kentucky's similar 3-drug protocol, the Chief Justice, joined by Justice Alito and Justice Kennedy, concluded that a state's refusal to alter its lethal injection protocol could violate the Eighth Amendment only if an inmate first identified a feasible, readily implemented alternative procedure that would significantly reduce a substantial risk of severe pain. Justice Thomas, joined by Justice Scalia, thought the protocol passed muster because it was not intended to, quote, add elements of terror, pain, or disgrace to the death penalty, unquote. Justice Breyer reached the same result because he saw no evidence that the protocol created, quote, a significant risk of unnecessary suffering, unquote. And though Justice Stevens objected to the continued use of the death penalty, he agreed that petitioner's evidence was insufficient. After this court decided Bays, it denied review in a case seeking to challenge Missouri's similar lethal injection protocol, Taylor v. Crawford, where certiorari was denied. But that still was not the end of it. Next, Mr. Bucklew and other inmates unsuccessfully challenged Missouri's protocol in state court, alleging that it had been adopted in contravention of Missouri's Administrative Procedure Act, as in Middleton v. Missouri Department of Corrections, where certiorari was denied. They also unsuccessfully challenged the protocol in federal court, this time alleging it was preempted by various federal statutes, as in Ringo v. Lombardi. And Mr. Bucklew sought to intervene in yet another lawsuit alleging that Missouri's protocol violated the Eighth Amendment because unqualified personnel might botch its administration. That lawsuit failed too, as in Clemens v. Crawford. While all this played out, pressure from anti-death penalty advocates induced the company that manufactured sodium thiopental to stop supplying it for use in executions. As a result, the state was unable to proceed with executions until it could change its lethal injection protocol again. This it did in 2012, prescribing the use of a single drug, the sedative propofol. Soon after that, Mr. Bucklew and other inmates sued to invalidate this new protocol as well, alleging that it would produce excruciating pain and violate the Eighth Amendment on its face. After the state revised the protocol in 2013 to use the sedative pentobarbital instead of propofol, the inmates amended their complaint to allege that pentobarbital would likewise violate the Constitution. Things came to a head in 2014. With its new protocol in place and the necessary drugs now available, the state scheduled Mr. Bucklew's execution for May 21st. But 12 days before the execution, Mr. Bucklew filed yet another lawsuit, the one now before us. In this case, he presented an as-applied Eighth Amendment challenge to the state's new protocol. Whether or not it would cause excruciating pain for all prisoners, as his previous lawsuit alleged, Mr. Bucklew now contended that the state's protocol would cause him severe pain because of his particular medical condition. Mr. Bucklew suffers from a disease called cavernous hemangioma, which causes vascular tumors, which are clumps of blood vessels, to grow in his head, neck, and throat. His complaint alleged that his condition could prevent the pentobarbital from circulating properly in his body, that the use of a chemical dye to flush the intravenous line could cause his blood pressure to spike and his tumors to rupture, and that pentobarbital could interact adversely with his other medications. These latest protocol challenges yielded mixed results. The district court dismissed both the inmate's facial challenge and Mr. Bucklew's as-applied challenge, but at Mr. Bucklew's request, this court agreed to stay his execution until the Eighth Circuit could hear his appeal. Bucklew v. Lombardi, 2014. Ultimately, the Eighth Circuit affirmed the dismissal of the facial challenge in Zink v. Lombardi of 2015. Then, turning to the as-applied challenge and seeking to apply the test set forth by the Bayes plurality, the court held that Mr. Bucklew's complaint failed as a matter of law to identify an alternative procedure that would significantly reduce the risks he alleged would flow from the state's lethal injection protocol. Yet despite this dispositive shortcoming, the Court of Appeals decided to give Mr. Bucklew another chance to plead his case. The court stressed that, on remand before the district court, Mr. Bucklew had to identify, quote, at the earliest possible time, unquote, a feasible, readily implemented alternative procedure that would address those risks. Shortly after the Eighth Circuit issued its judgment, this court decided Glossop v. Gross of 2015, rejecting a challenge to Oklahoma's lethal injection protocol. There, the court clarified that the Chief Justice's plurality opinion in Bayes was controlling under Marks v. United States of 1977. In doing so, it reaffirmed that an inmate cannot successfully challenge a method of execution under the Eighth Amendment unless he identifies, quote, an alternative that is feasible, readily implemented, and in fact significantly reduces a substantial risk of severe pain, unquote. Justice Thomas, joined by Justice Scalia, reiterated his view that the Eighth Amendment, quote, prohibits only those methods of execution that are deliberately designed to inflict pain, unquote. But he joined the court's opinion because it correctly explained why petitioner's claim failed even under the controlling opinion in Bayes. Despite the Eighth Circuit's express instructions, when Mr. Bucklew returned to the district court in 2015, he still refused to identify an alternative procedure that would significantly reduce his alleged risk of pain. Instead, he insisted that inmates should have to carry this burden only in facial, not as-applied challenges. Finally, after the district court gave him, quote, one last opportunity, unquote, Mr. Bucklew filed a fourth amended complaint in which he claimed that execution by lethal gas was a feasible and available alternative method that would significantly reduce his risk of pain. Mr. Bucklew later clarified that the lethal gas he had in mind was nitrogen, which neither Missouri nor any other state had ever used to carry out an execution. The district court allowed Mr. Bucklew extensive discovery on his new proposal, but even at the close of discovery in 2017, the district court still found the proposal lacking and granted the state's motion for summary judgment. By this point in the proceedings, Mr. Bucklew's contentions about the pain he might suffer had evolved considerably. He no longer complained about circulation of the drug, the use of dye, or adverse drug interactions. Instead, his main claim now was that he would experience pain during the period after the pentobarbital started to take effect, but before it rendered him fully unconscious. According to his expert, Dr. Joel Zivit, while in this semi-conscious twilight stage, Mr. Bucklew would be unable to prevent his tumors from obstructing his breathing, which would make him feel like he was suffocating. Dr. Zivit declined to say how long this twilight stage would last. When pressed, however, he referenced a study on euthanasia in horses. He claimed that the horses in the study had displayed some amount of brain activity as measured with an EEG for up to 4 minutes after they were given a large dose of pentobarbital. Based on Dr. Zivit's testimony, the district court found a triable issue as to whether there was a substantial risk that Mr. Bucklew would experience choking and the inability to breathe for up to 4 minutes if he were executed by lethal injection. Even so, the court held Mr. Bucklew's claim failed because he had produced no evidence that his proposed alternative, execution by nitrogen hypoxia, would significantly reduce that risk. This time, a panel of the Eighth Circuit affirmed. The panel held that Mr. Bucklew had produced no evidence that the risk of pain he alleged would be substantially reduced by use of nitrogen hypoxia instead of lethal injection as the method of execution. Judge Colleton dissented, arguing that the evidence raised a triable issue as to whether nitrogen gas would render Bucklew insensate more quickly than pentobarbital. The full court denied rehearing en banc over a dissent by Judge Kelly, who maintained that, while prisoners pursuing facial challenges to a state execution protocol must plead and prove an alternative method of execution under Bayes and Glossop, prisoners like Mr. Bucklew who pursue as-applied challenges should not have to bear that burden. On the same day Mr. Bucklew was scheduled to be executed, this court granted him a second stay of execution. We then agreed to hear his case to clarify the legal standards that govern an as-applied Eighth Amendment challenge to a state's method of carrying out a death sentence. We begin with Mr. Bucklew's suggestion that the test for lethal injection protocol challenges announced in Bayes and Glossop should govern only facial challenges, not as-applied challenges like his. In evaluating this argument, we first examine the original and historical understanding of the Eighth Amendment and our precedent in Bayes and Glossop. We then address whether, in light of those authorities, it would be appropriate to adopt a different constitutional test for as-applied claims. The Constitution allows capital punishment. In fact, death was the standard penalty for all serious crimes at the time of the founding. Nor did the later edition of the Eighth Amendment outlaw the practice. On the contrary, the Fifth Amendment, added to the Constitution at the same time as the Eighth, expressly contemplates that a defendant may be tried for a capital crime and deprived of life as a penalty, so long as proper procedures are followed, and the first Congress, which proposed both amendments, made a number of crimes punishable by death. Of course, that doesn't mean the American people must continue to use the death penalty. The same Constitution that permits states to authorize capital punishment also allows them to outlaw it. But it does mean that the judiciary bears no license to end a debate reserved for the people and their representatives. While the Eighth Amendment doesn't forbid capital punishment, it does speak to how states may carry out that punishment, prohibiting methods that are cruel and unusual. What does this term mean? At the time of the framing, English law still formally tolerated certain punishments even though they had largely fallen into disuse, punishments in which terror, pain, or disgrace were superadded to the penalty of death. These included such disgusting practices as dragging the prisoner to the place of the execution, disemboweling, quartering, public dissection, and burning alive. Methods of execution like these readily qualified as cruel and unusual as a reader at the time of the Eighth Amendment's adoption would have understood those words. They were undoubtedly cruel, a term often defined to mean pleased with hurting others, inhuman, hard-hearted, void of pity, wanting compassion, savage, barbarous, or unrelenting. And by the time of the founding, these methods had fallen out of use and so had become unusual. Contemporary evidence confirms that the people who ratified the Eighth Amendment would have understood it in just this way. Patrick Henry, for one, warned that unless the Constitution was amended to prohibit cruel and unusual punishments, Congress would be free to inflict tortures and barbarous punishments. Many early commentators likewise described the Eighth Amendment as ruling out the use of the rack or the stake or any of those horrid modes of torture devised by human ingenuity for the gratification of fiendish passion. Justice Story even remarked that he thought the prohibition of cruel and unusual punishments likely unnecessary because no free government would ever authorize atrocious methods of execution like these. Consistent with the Constitution's original understanding, this court in Wilkerson v. Utah, 1879, permitted an execution by firing squad while observing that the Eighth Amendment forbade the gruesome methods of execution described above. A few years later, the court upheld a sentence of death by electrocution while observing that, though electrocution was a new mode of punishment and therefore perhaps could be considered unusual, it was not cruel in the constitutional sense. The punishment of death is not cruel, within the meaning of that word as used in the Constitution. Cruelty implies something inhuman and barbarous, something more than the mere extinguishment of life. It is instructive, too, to contrast the modes of execution the Eighth Amendment was understood to forbid with those it was understood to permit. At the time of the amendment's adoption, the predominant method of execution in this country was hanging. While hanging was considered more humane than some of the punishments of the Old World, it was no guarantee of a quick and painless death. Many and perhaps most hangings were evidently painful for the condemned person because they caused death slowly, and whether a hanging was painless or painful seems to have been largely a matter of chance. The force of the drop could break the neck and sever the spinal cord, making death almost instantaneous, but that was hardly assured given the techniques that prevailed at the time. More often it seems the prisoner would die from loss of blood flow to the brain, which could produce unconsciousness usually within seconds, or suffocation, which could take several minutes. But while hanging could and often did result in significant pain, its use was virtually never questioned. Presumably that was because, in contrast to punishments like burning and disemboweling, hanging wasn't intended to be painful, and the risk of pain involved was considered unfortunate but inevitable. What does all this tell us about how the Eighth Amendment applies to methods of execution? For one thing, it tells us that the Eighth Amendment does not guarantee a prisoner a painless death, something that, of course, isn't guaranteed to many people, including most victims of capital crimes. Instead, what unites the punishments of the Eighth Amendment was understood to forbid, and distinguishes them from those it was understood to allow, is that the former were long disused, unusual forms of punishment that intensified the sentence of death with a cruel superaddition of terror, pain, or disgrace. This court has yet to hold that a state's method of execution qualifies as cruel and unusual, and perhaps understandably so. Far from seeking to superadd terror, pain, or disgrace to their executions, the states have often sought more nearly the opposite, exactly as Justice Story predicted. Through much of the 19th century, states experimented with technological innovations aimed at making hanging less painful. In the 1880s, following the recommendation of a commission tasked with finding the most humane and practical method known to modern science of carrying into effect the sentence of death, the state of New York replaced hanging with electrocution. Several states followed suit in the belief that electrocution is less painful and more humane than hanging. Other states adopted lethal gas after concluding it was the most humane method of execution known to modern science, and beginning in the 1970s, the search for a less painful mode of execution led many states to switch to lethal injection. Notably, all of these innovations occurred not through this court's intervention, but through initiative of people and their representatives. Still, accepting the possibility that a state might try to carry out an execution in an impermissibly cruel and unusual manner, how can a court determine when a state has crossed the line? The Chief Justice's opinion in Bayes, which a majority of the court held to be controlling in Glossop, supplies critical guidance. It teaches that, where, as here, the question in dispute is whether the state's chosen method of execution cruelly superadds pain to the death sentence, a prisoner must show a feasible and readily implemented alternative method of execution that would significantly reduce a substantial risk of severe pain, and that the state has refused to adopt without a legitimate penological reason. Glossop left no doubt that this standard governs all Eighth Amendment method of execution claims. In reaching this conclusion, Bayes and Glossop recognize that the Eighth Amendment does not demand the avoidance of all risk of pain in carrying out executions. To the contrary, the Constitution affords a measure of deference to a state's choice of execution procedures, and does not authorize courts to serve as boards of inquiry charged with determining best practices for executions. The Eighth Amendment does not come into play unless the risk of pain associated with the state's method is substantial when compared to a known and available alternative. Nor do Bayes and Glossop suggest that traditionally accepted methods of execution, such as hanging, the firing squad, electrocution, and lethal injection, are necessarily rendered unconstitutional as soon as an arguably more humane method like lethal injection becomes available. There are, the court recognized, many legitimate reasons why a state might choose, consistent with the Eighth Amendment, not to adopt a prisoner's preferred method of execution. A state can't be faulted for failing to use lethal injection drugs that it's unable to procure through good faith efforts. A state has a legitimate interest in selecting a method it regards as preserving the dignity of the procedure, and a state isn't required to modify its protocol in ways that would require the involvement of persons whose professional ethics, rules, or traditions impede their participation. As we've seen, two members of the court whose votes were essential to the judgment in Glossop argue that establishing cruelty consistent with the Eighth Amendment's original meaning demands slightly more than the majority opinion there suggested. Instead of requiring an inmate to establish that a state has unreasonably refused to alter its method of execution to avoid a risk of unnecessary pain, Justice Thomas and Justice Scalia contended that an inmate must show that the state intended its method to inflict such pain. But revisiting that debate isn't necessary here because, as we'll see, the state was entitled to summary judgment in this case even under the more forgiving Bayes-Glossop test. Before turning to the application of Bayes and Glossop, however, we must confront Mr. Bucklew's argument that a different standard entirely should govern as-applied challenges like his. He admits that Bayes and Glossop supply the controlling test in facial challenges to a state's chosen method of execution. but he suggests that he should not have to prove an alternative method of execution in his as-applied challenge because certain categories of punishment are manifestly cruel, without reference to any alternative methods. He points to burning at the stake, crucifixion, and breaking on the wheel as examples of categorically cruel methods. And he says we should use this case to add to the list of categorically cruel methods any method that, as applied to a particular inmate, will pose a substantial and particular risk of grave suffering due to the inmate's unique medical condition. The first problem with this argument is that it's foreclosed by precedent. Glossop expressly held that identifying an available alternative is required of all Eighth Amendment method of execution claims alleging cruel pain, and just as binding as this holding is the reasoning underlying it. Distinguishing between constitutionally permissible and impermissible degrees of pain, Bayes and Glossop explained, is a necessary comparative exercise. To decide whether the state has cruelly superadded pain to the punishment of death isn't something that can be accomplished by examining the state's proposed method in a vacuum, but only by comparing the method with a viable alternative. As Mr. Bucklew acknowledges when speaking of facial challenges, this comparison provides the needed metric to measure whether the state is lawfully carrying out an execution or inflicting gratuitous pain. Yet it is that very comparison and needed metric Mr. Bucklew would now have us discard. Nor does he offer some persuasive reason for overturning our precedent. To the contrary, Mr. Bucklew simply repeats the same argument that the principal dissent offered and the court expressly and thoughtfully rejected in Glossop. Just as Mr. Bucklew argues here, the dissent there argued that certain methods of execution, like burning at the stake, should be declared categorically off limits, and just as Mr. Bucklew submits here, the dissent there argued that any other intolerably painful method of execution should be added to this list. Mr. Bucklew's submission thus amounts to no more than a headlong attack on precedent. Mr. Bucklew's argument fails for another independent reason. It is inconsistent with the original and historical understanding of the Eighth Amendment on which Bayes and Glossop rest. As we've seen, when it comes to determining whether a punishment is unconstitutionally cruel because of the pain involved, the law has always asked whether the punishment superadds pain well beyond what's needed to effectuate a death sentence, and answering that question has always involved a comparison with available alternatives, not some abstract exercise in categorical classification. At common law, the ancient and barbaric methods of execution Mr. Bucklew cites were understood to be cruel precisely because, by comparison to other methods, they went so far beyond what was needed to carry out a death sentence that they could only be explained as reflecting the infliction of pain for pain's sake. Meanwhile, hanging carried with it an acknowledged and substantial risk of pain, but was not considered cruel because the risk was thought, by comparison to other known methods, to involve no more pain than was reasonably necessary to impose a lawful death sentence. What does the principal dissent have to say about all this? It acknowledges that Glossop's comparative requirement helps prevent facial method of execution claims from becoming a backdoor means to abolish the death penalty. But, the dissent assures us, there's no reason to worry that as applied method of execution challenges might be used that way. This assurance misses the point. As we've explained, the alternative method requirement is compelled by our understanding of the Constitution, not by mere policy concerns. With that, the dissent is left only to rehash the same argument that Mr. Bucklew offers. The dissent insists that some forms of execution are just categorically cruel. At first, and like others who have made this argument, the dissent offers little more than intuition to support its conclusion. Ultimately, though, even it bows to the necessity of something firmer. If a comparator is needed to assess whether an execution is cruel, the dissent tells us, we should compare the pain likely to follow from the use of a lethal injection in this case with the pain-free use of lethal injections in mine run cases. But that's just another way of saying executions must always be carried out painlessly because they can be carried out painlessly most of the time, a standard the Constitution has never required and this court has rejected time and time again. To determine whether the state is cruelly superadding pain, our precedents in history require asking whether the state had some other feasible and readily available method to carry out this lawful sentence that would have significantly reduced a substantial risk of pain. That Mr. Bucklew and the dissent failed to respect the force of our precedents, or to grapple with the understanding of the Constitution in which our precedents rest, is more than enough reason to reject their view that as applied and facial challenges should be treated differently. But it turns out their position on this score suffers from further problems too, problems that neither Mr. Bucklew nor the dissent even attempts to address. Take this one. A facial challenge is really just a claim that the law or policy at issue is unconstitutional in all of its applications. So classifying a lawsuit as facial or as applied affects the extent to which the invalidity of the challenged law must be demonstrated and the corresponding breadth of the remedy. but it does not speak at all to the substantive rule of law necessary to establish a constitutional violation. Surely it would be strange for the same words of the Constitution to bear entirely different meanings depending only on how broad a remedy the plaintiff chooses to seek. And surely, too, it must count for something that we have found not a single court decision in over 200 years suggesting that the Eighth Amendment's meaning shifts in this way. To the contrary, our precedent suggests just the opposite. In the related context of an Eighth Amendment challenge to conditions of confinement, we have seen no basis whatsoever for applying a different legal standard to deprivations inflicted upon all prisoners, and those afflicted upon particular prisoners. Here's yet another problem with Mr. Bucklew's argument. It invites pleading games. The line between facial and as-applied challenges can sometimes prove amorphous, and not so well defined. Consider an example. Suppose an inmate claims that the state's lethal injection protocol violates the Eighth Amendment when used to execute anyone with a very common but not quite universal health condition. Should such a claim be regarded as facial or as applied? In another context, we sidestepped a debate over how to categorize a comparable claim, one that neither sought to strike the challenge law in all its applications nor was limited to the plaintiff's particular case. To hold now for the first time that choosing a label changes the meaning of the Constitution would only guarantee a good deal of litigation over labels, with lawyers on each side seeking to classify cases to maximize their tactical advantage. Unless increasing the delay and cost involved in carrying out executions is the point of the exercise, it's hard to see the benefit in placing so much weight on what can be an abstruse exercise. Finally, the burden Mr. Bucklew must shoulder under the Bayes-Glossop test can be overstated. An inmate seeking to identify an alternative method of execution is not limited to choosing among those presently authorized by a particular state's law. Missouri itself seemed to acknowledge as much at oral argument. So, for example, a prisoner may point to a well-established protocol in another state as a potentially viable option. Of course, in a case like that, a court would have to inquire into the possibility that one state possessed a legitimate reason for deciding to adopt the protocol of another. And existing state law might be relevant to determining the proper procedural vehicle for the inmate's claim. But the Eighth Amendment is the supreme law of the land, and the comparative assessment it requires can't be controlled by the state's choice of which methods to authorize in its statute. In light of this, we see little likelihood that an inmate facing a serious risk of pain will be unable to identify an available alternative, assuming, of course, that the inmate is more interested in avoiding unnecessary pain than in delaying his execution. Having reconfirmed that anyone bringing a method of execution claim alleging the infliction of unconstitutionally cruel pain must meet the Bayes-Glossop test, we can now turn to the question whether Mr. Bucklew is able to satisfy that test. Has he identified a feasible and readily implemented alternative method of execution the state refused to adopt without a legitimate reason, even though it would significantly reduce a substantial risk of severe pain? Because the case comes to us after the entry of summary judgment, this appeal turns on whether Mr. Bucklew has shown a genuine issue of material fact warranting a trial. We begin with the question of a proposed alternative method. Through much of this case, and despite many opportunities, Mr. Bucklew refused to identify any alternative method of execution, choosing instead to stand on his argument that Bayes and Glossop's legal standard doesn't govern as-applied challenges like his, even after the Eighth Circuit rejected that argument. Only when the district court warned that his continued refusal to abide this court's precedents would result in immediate dismissal did Mr. Bucklew finally point to nitrogen hypoxia. The district court then afforded Mr. Bucklew extensive discovery to explore the viability of that alternative. But even after all that, we conclude Mr. Bucklew has failed for two independent reasons to present a triable question of on the validity of nitrogen hypoxia as an alternative to the state's lethal injection protocol. First, an inmate must show that his proposed alternative method is not just theoretically feasible but also readily implemented. This means that the inmate's proposal must be sufficiently detailed to permit a finding that the state could carry it out relatively easily and reasonably quickly. Mr. Bucklew's bare-bones proposal falls well short of that standard. He has presented no evidence on essential questions like how nitrogen gas should be administered, using a single gas chamber, a tent, a hood, a mask, or some other delivery device, in what concentration, either pure nitrogen or some mixture, and how quickly and for how long it should be introduced, or how the state might ensure the safety of the execution team, including protecting them against the risk of gas leaks. Instead of presenting the state with a readily implemented alternative method, Mr. Bucklew and the principal dissent point to reports from correctional authorities in other states indicating that additional study is needed to develop a protocol for execution by nitrogen hypoxia. That is a proposal for more research, not the readily implemented alternative that Bayes and Glossop require. Second, and relatedly, the state had a legitimate reason for declining to switch from its current method of execution as a matter of law. Rather than point to a proven alternative method, Mr. Bucklew sought the adoption of an entirely new method, one that had never been used to carry out an execution and had no track record of successful use. But choosing not to be the first to experiment with a new method of execution is a legitimate reason to reject it. In Bayes, we observed that no other state had adopted the one-drug protocol the inmates sought, and they had proffered no study showing their one-drug protocol would be as effective and humane as the state's existing three-drug protocol. Under those circumstances, we held as a matter of law that Kentucky's refusal to adopt the inmates' proffered protocol could not constitute a violation of the Eighth Amendment. The Eighth Amendment prohibits states from dredging up archaic, cruel punishments or perhaps inventing new ones, but it does not compel a state to adopt untried and untested and thus unusual in the constitutional sense methods of execution. Even if a prisoner can carry his burden of showing a readily available alternative, he must still show that it would significantly reduce a substantial risk of severe pain. A minor reduction in risk is insufficient. The difference must be clear and considerable. Over the course of this litigation, Mr. Bucklew's explanation why nitrogen hypoxia meets this standard has evolved significantly, but neither of the two theories he has advanced in this court turns out to be supported by record evidence. First, Mr. Bucklew points to several risks that he alleges could result from use of the state's lethal injection protocol that would not be present if the state used nitrogen gas. For example, he says the execution team might try to insert an IV into one of his peripheral veins, which could cause the vein to rupture, or the team might instead use an allegedly painful cut-down procedure to access his femoral vein. He also says that he might be forced to lie flat on his back during the execution, which could impair his breathing even before the pentobarbital is administered. And he says the stress from all this could cause his tumors to bleed, further impairing his breathing. These risks we may assume would not exist if Mr. Bucklew were executed by his preferred method of nitrogen hypoxia. The problem with all these contentions is that they rest on speculation unsupported, if not affirmatively contradicted, by the evidence in this case. Nor does the principal dissent contend otherwise. So, for example, uncontroverted record evidence indicates that the execution team will have discretion to adjust the gurney to whatever position is in Mr. Bucklew's best medical interests. Moreover, the state agreed in the district court that it would not try to place an IV in Mr. Bucklew's compromised peripheral veins. And, assuming without granting that using a cut-down would raise issues under the Eighth Amendment, the state's expert, Dr. Michael Antognini, testified without contradiction that it should be possible to place an IV in Mr. Bucklew's femoral vein without using a cut-down procedure. Mr. Bucklew responds by pointing to the warden's testimony that he once saw medical staff perform a cut-down as part of an execution. But there's no evidence that what the warden saw was an attempt to access a femoral vein, as opposed to some other vein. Moreover, to the extent the record is unclear on any of these issues, Mr. Bucklew had ample opportunity to conduct discovery and develop a factual record concerning exactly what procedures the state planned to use. He failed to do so, presumably because the thrust of a constitutional claim was that any attempt to execute him via lethal injection would be unconstitutional, regardless of the specific procedures the state might use. As the Court of Appeals explained, having taken the position that any lethal injection procedure would violate the Eighth Amendment, Mr. Bucklew made no effort to determine what changes, if any, the state should make in applying its lethal injection protocol to him, and he never urged the district court to establish a suitable fact-finding procedure to define the as-applied lethal injection protocol the state intends to use. Second, Mr. Bucklew contends that the lethal injection itself will expose him to a substantial risk of severe pain that could be eliminated by adopting his preferred method. He claims that once the sedative pentobarbital is injected, he will lose the ability to manage the tumors in his airway, and as a result will experience a sense of suffocation for some period of time before the state's sedative renders him fully unconscious. It is during this in-between twilight stage, according to his expert Dr. Zivit, that Mr. Bucklew is likely to experience prolonged feelings of suffocation and excruciating pain. Mr. Bucklew admits that similar feelings of suffocation could occur with nitrogen, the only difference being the potential duration of the so-called twilight stage. He contends that with nitrogen, the stage would last at most 20 to 30 seconds, while with pentobarbital it could last up to several minutes. But here again, the record contains insufficient evidence to permit Mr. Bucklew to avoid summary judgment. For starters, in the courts below, Mr. Bucklew maintained he would have trouble managing his airway only if he were forced to lie supine, which, as we've explained, the evidence shows he won't be. The dissenters don't address this point. But even indulging his new claim that he will have this difficulty regardless of position, he still has failed to present colorable evidence that nitrogen would significantly reduce his risk of pain. We can assume for argument's sake that Mr. Bucklew is correct that with nitrogen, the twilight stage would last 20 to 30 seconds. The critical question then is how long that period might last with pentobarbital. The state's expert, Dr. Antognini, testified that pentobarbital 2 would render Mr. Bucklew fully unconscious and incapable of experiencing pain in 20 to 30 seconds. Dr. Zivit disagreed, but when he was asked how long he thought the twilight stage would last with pentobarbital, his testimony was evasive. Eventually, he said his number would be longer than 20 to 30 seconds, but he declined to say how much longer. Instead, he referenced a 2015 study on euthanasia in horses. He said the study found that when horses were given a large dose of pentobarbital along with other drugs, they exhibited isoelectric EEG, a complete absence of detectable brain activity, after 52 to 240 seconds. The district court assumed Dr. Zivit meant that pain might be felt until measurable brain activity ceases, and that extrapolating from the horse study, it might take up to 4 minutes for pentobarbital to induce a state in which Mr. Bucklew could no longer sense that he is choking or unable to breathe. The district court acknowledged, however, that this might be a generous interpretation of Dr. Zivit's testimony. In fact, there is nothing in the record to suggest that Mr. Bucklew will be capable of experiencing pain for significantly more than 20 to 30 seconds after being injected with pentobarbital. For one thing, Mr. Bucklew's lawyer now admits that Dr. Zivit crossed up the numbers from the horse study. The study actually reported that the horses displayed isoelectric EEG between 2 and 52 seconds after infusion of pentobarbital was completed, with an average time of less than 24 seconds. So, if anything, the horse study appears to bolster Dr. Antognini's time estimate. For another thing, everyone now also seems to acknowledge that isoelectric EEG is the wrong measure. Dr. Zivit never claimed the horses were capable of experiencing pain until they reached isoelectric EEG, and Mr. Bucklew's lawyer now concedes that doctors perform major surgery on human patients with measurable EEG readings, which strongly suggests that Mr. Bucklew will be insensible to pain before reaching isoelectric EEG. Finally, the record evidence even allows the possibility that nitrogen could increase the risk of pain. Because Dr. Zivit declined to testify about the likely effects of nitrogen gas, Mr. Bucklew must rely on Dr. Antognini's testimony, and while Dr. Antognini did say he thought nitrogen's onset of action could be relatively fast, he added that the effects of nitrogen could vary depending on exactly how it would be administered, information Mr. Bucklew hadn't provided. Indeed, he stated that depending on how it's used, you might get more suffering from nitrogen gas than you would have from the state's current protocol. Of course, the principal dissent maintains that Dr. Zivit's testimony supports an inference that pentobarbital might cause Mr. Bucklew to suffer for a prolonged period, but its argument rests on a number of mistakes about the record. For example, the dissent points to Dr. Zivit's remark that with pentobarbital, the period of time between receiving the injection and death could range over a few minutes to many minutes. From this, the dissent concludes that Mr. Bucklew may suffer for up to several minutes. But everyone agrees that the relevant question isn't how long it will take Mr. Bucklew to die, but how long he will be capable of feeling pain. Seeking to address the problem, the dissent next points to another part of Dr. Zivit's testimony and says it means that Mr. Bucklew could experience pain during the entire time between injection and death. But the dissent clips the relevant quotation. As the full quotation makes clear, Dr. Zivit claimed that Mr. Bucklew might be able to maintain the integrity of his airway until he died, but he carefully avoided claiming that Mr. Bucklew would be capable of feeling pain until he died. To avoid this problem, the dissent quotes Dr. Zivit's assertions that pentobarbital might not produce rapid unconsciousness and that Mr. Bucklew's suffering with pentobarbital could be prolonged. But Dr. Zivit's statements here, too, fail to specify how long Mr. Bucklew is likely to be able to feel pain. The hard fact is that when Dr. Zivit was finally compelled to offer a view on this question, his only response was to refer to the horse study. The dissent's effort to suggest that Dr. Zivit did not rely exclusively or even heavily on that study is belied by, among many other things, Mr. Bucklew's own brief in this court, which asserted that the twilight stage during which he might feel pain could last between 52 and 240 seconds, based entirely on a citation of Dr. Zivit's incorrect testimony about the horse study. In sum, even if execution by nitrogen hypoxia were a feasible and readily implemented alternative to the state's chosen method, Mr. Bucklew has still failed to present any evidence suggesting that it would significantly reduce his risk of pain. For that reason as well, the state has entitled summary judgment on Mr. Bucklew's Eighth Amendment claim. Both the state and the victims of crime have an important interest in the timely enforcement of a sentence. Those interests have been frustrated in this case. Mr. Bucklew committed his crimes more than 2 decades ago. He exhausted his appeal in separate state and federal habeas corpus challenges more than a decade ago. Yet since then he has managed to secure delay through lawsuit after lawsuit. He filed his current challenge just days before his scheduled execution. That suit has now carried on for 5 years and yielded 2 appeals to the 8th Circuit, 2 11th-hour stays of execution, and plenary consideration in this court. And despite all this, his suit in the end amounts to little more than an attack on settled precedent, lacking enough evidence even to survive summary judgment, and on not just one, but many essential legal elements set forth in our case law and required by the Constitution's original meaning. The people of Missouri, the surviving victims of Mr. Bucklew's crimes, and others like them deserve better. Even the principal dissent acknowledged that the long delays that now typically occur between the time an offender is sentenced to death and his execution are excessive. The answer is not, as the dissent incongruously suggests, to reward those who interpose delay with a decree ending capital punishment by judicial fiat. Under our Constitution, the question of capital punishment belongs to the people and their representatives, not the courts, to resolve. The proper role of courts is to ensure that method of execution challenges to lawfully issued sentences are resolved fairly and expeditiously. Courts should police carefully against such attempts to use such challenges as tools to interpose unjustified delay. Last-minute stays should be the extreme exception, not the norm, and the last-minute nature of an application that could have been brought earlier or an applicant's attempt of manipulation may be grounds for denial of a stay. So, for example, we have vacated a stay entered by a lower court as an abuse of discretion where the inmate waited to bring an available claim until just 10 days before his scheduled execution for a murder he had committed 24 years earlier. If litigation is allowed to proceed, federal courts can and should protect settled state judgments from undue interference by invoking their equitable powers to dismiss or curtail suits that are pursued in a dilatory fashion or based on speculative theories. The judgment of the Court of Appeals is affirmed. Now, there are a couple important things talked about in that opinion, as well as during the oral arguments I want to talk about. So, the court based their decision off the precedent cases Bayes v. Rees and Glossop v. Gross, which together form what's known as the Bayes-Glossop test. This test is used when challenging a punishment or method of execution. In order to pass the test, the challenger must prove the punishment or method of execution is creating a significant amount of unnecessary pain, and that there is another readily available and feasible alternative which the state has not used and which will significantly reduce pain. The court is saying here that Bucklew didn't pass any part of the test. They're saying he neither proved that the pentobarbital would cause him a significant amount of unnecessary pain, nor did he prove that nitrogen hypoxia was a readily available, feasible alternative, nor did he prove that an execution via nitrogen hypoxia would significantly reduce pain. He also made the point a couple times that the legality of the death penalty is not for the courts to decide. It's for people and the representatives to decide how executions should take place, and even if they should take place at all. So next up, we have Justice Kavanaugh, who wrote a concurring opinion, and he said, "When an inmate raises an as-applied constitutional challenge to a particular method of execution, that is, a challenge to a method of execution that is constitutional in general, but that the inmate says is very likely to cause him severe pain, one question is whether the inmate must identify an available alternative method of execution that would significantly reduce the risk of severe pain." Applying our recent decisions in Glossop v. Gross and Bayes v. Rees, the court's answer to that question is yes. Under those precedents, I agree with the court's holding and join the court's opinion. I write to underscore the court's additional holding that the alternative method of execution need not be authorized under current state law, a legal issue that had been uncertain before today's decision. As the court notes, it follows from that additional holding that the burden of the alternative method requirement can be overstated. Indeed, the court states, we see little likelihood that an inmate facing a serious risk of pain will be unable to identify an available alternative. In other words, an inmate who contends that a particular method of execution is very likely to cause him severe pain should ordinarily be able to plead some alternative method of execution that would significantly reduce the risk of severe pain. At oral argument in this court, the state suggested that the firing squad would be such an available alternative, if adequately pleaded. Justice Sotomayor has likewise explained that the firing squad is an alternative method of execution that generally causes an immediate and certain death, with close to zero risk of a botched execution. I do not here prejudge the question whether the firing squad or any other alternative method of execution would be a feasible and readily implemented alternative for every state. Rather, I simply emphasize the court's statement that we see little likelihood that an inmate facing a serious risk of pain will be unable to identify an available alternative. So basically what he's saying is that he's really hitting home on the point that Bucklew refused to identify an available alternative method until very late in the trial. So he's saying if this was really about the cruelty of the death penalty, then Bucklew would have identified an alternative method much earlier than when he did. Going along with Gorsuch and Kavanaugh, Justice Thomas wrote a concurring opinion as well. He said, "I adhere to my view that a method of execution violates the Eighth Amendment only if it is deliberately designed to inflict pain. Because there is no evidence that Missouri designed its protocol to inflict pain on anyone, let alone Russell Bucklew, I would end the inquiry there. Nonetheless, I join the court's opinion in full because it correctly explains why Bucklew's claim fails even under the court's precedents. I write separately to explain why Justice Breyer's dissenting opinion does not cast doubt on this standard. As I explained in Bayes, the evil the Eighth Amendment targets is intentional infliction of gratuitous pain. The historical evidence shows that the framers sought to disable Congress from imposing various kinds of torturous punishments such as gibbeting, burning at the stake, and embalming alive, beheading, and quartering. In England, these aggravated forms of capital punishments were superadded to increase terror and disgrace for very atrocious crimes, such as treason and murder. The founding generation ratified the Eighth Amendment to reject that practice, contemplating that capital punishment would continue but without those punishments deliberately designed to superadd pain. Under this view, the constitutionality of a particular execution thus turns on whether the government deliberately designed the method of execution to inflict pain, without regard to the subjective intent of the executioner. Contrary to Justice Breyer's suggestion, my view does not render the Eighth Amendment a static prohibition, prescribing only the same things that it prescribed in the 18th century. A method of execution not specifically contemplated at the founding could today be imposed to superadd terror, pain, or disgrace. Thankfully, and consistent with Justice Story's view that the Eighth Amendment is wholly unnecessary in a free government, states do not attempt to devise such diabolical punishments. It is therefore unsurprising that, despite Justice Breyer's qualms about the death penalty, this court has never held a method of execution unconstitutional. Because the court correctly declines to do so again today, I join in full. So there, Clarence Thomas is kind of going on the defense from Justice Breyer's dissent, which we'll get into in a minute. He's basically saying that, reiterating his idea that in order for a death penalty procedure to be found against the Eighth Amendment, it has to be specifically designed to inflict pain. And he says this lethal injection, it causes pain, but it wasn't designed that way. It wasn't designed to be painful for the prisoner. So he's saying this doesn't violate the Eighth Amendment. Now let's hear the dissenting opinions. The first is from Justice Breyer, who said, Justice Breyer, with whom Justice Ginsburg, Justice Sotomayor, and Justice Kagan join as to all but Part 3 dissenting. So this is a three-part dissent, and Justices Ginsburg, Sotomayor, and Kagan agree with the first two, but not the third. The court's decision in this case raises three questions. The first is primarily a factual question, namely whether Bucklew has established genuine issues of material fact concerning whether executing him by lethal injection would cause him excessive suffering. The second is primarily a legal question, namely whether a prisoner like Bucklew with a rare medical condition must identify an alternative method by which the state may execute him. And the third is a more general question, namely how to minimize delays in executing offenders who have been condemned to death. I disagree with the majority's answers to all three questions. Bucklew cites evidence that executing him by lethal injection will cause the tumors that grow in his throat to rupture during his execution, causing him to sputter, choke, and suffocate on his own blood for up to several minutes before he dies. That evidence establishes at this stage of the proceedings that executing Bucklew by lethal injection risks subjecting him to constitutionally impermissible suffering. The majority holds that the state may execute him anyway. In my view, that holding violates the clear command of the Eighth Amendment. I begin with a factual question. Whether Bucklew has established that because of his rare medical condition, the state's current method of execution risks subjecting him to excessive suffering. There is no dispute as to the applicable summary judgment standard. Because the state moved for summary judgment, it can prevail if, but only if, it shows that there is no genuine dispute as to any material fact. On review, we examine the record as a whole, which includes depositions, documents, and affidavits or declarations, and we must construe the evidence in the light most favorable to Bucklew and draw every justifiable inference in his favor. Bucklew has easily established a genuine issue of material fact regarding whether an execution by lethal injection would subject him to impermissible suffering. The record indicates that Bucklew suffers from a congenital condition known as cavernous hemangioma that causes tumors filled with blood vessels to grow throughout his body, including in his head, face, neck, and oral cavity. The condition is rare. One study estimates that hemangiomas in the oral cavity occur in less than 1% of the population, and that hemangiomas like Bucklew's have been identified in 5 cases. Tumors grow out of Bucklew's lip and over his mouth, as well as on his hard and soft palate. One tumor also grows directly on Bucklew's uvula, which has become grossly enlarged as a result. Bucklew's tumors obstruct his airway and make it difficult for him to breathe. His difficulty breathing is chronic, but is particularly acute when he lies flat and the gravity pulls his engorged uvula into his airway. He often has to adjust the positioning of his head to prevent his uvula from obstructing his breathing. He sleeps at a 45-degree angle to facilitate breathing, and he often wakes up in the middle of the night gasping for air. Due to the sensitivity of his tumors, even minimal contact may cause him to hemorrhage. He has described past hemorrhages as squirting or leaking blood, and he states that the first thing he does each morning is to wipe the blood off his face that leaked from his nose and mouth as he slept. Bucklew's condition is progressive, and due to the risk of significant blood loss caused by the sensitivity of his tumors, it cannot be treated with surgery. Bucklew maintains that, as a result of his medical condition, executing him by lethal injection would prove excruciatingly painful. In support of this claim, Bucklew submitted sworn declarations and deposition testimony from an expert witness, Dr. Joel Zivit, an anesthesiologist. Dr. Zivit provided extensive testimony regarding the pain that Bucklew would likely endure in an execution by lethal injection. Dr. Zivit testified that in light of the degree to which Mr. Bucklew's airway is compromised by the hemangiomas and the particular psychological and physical effects of lethal injection, it is highly likely that Mr. Bucklew would be unable to maintain the integrity of his airway during the time after receiving the lethal injection and before death. Dr. Zivit explained that as a result of the highly friable and fragile state of the tissue of Mr. Bucklew's mouth and airway, Bucklew will likely experience hemorrhaging and or the possible rupture of the tumor on his uvula during his execution. Dr. Zivit added that the hemorrhaging will further impede Mr. Bucklew's airway by filling his mouth and airway with blood, causing him to choke and cough on his own blood. Dr. Zivit concluded that it is highly likely that Mr. Bucklew, given his specific congenital medical condition, cannot undergo lethal injection without experiencing the excruciating pain and suffering of suffocation, convulsions, and visible hemorrhaging. Dr. Zivit also testified about the duration of pain to which an execution by lethal injection would subject Bucklew, describing it as prolonged. Dr. Zivit stated that the effects of a pentobarbital injection are highly unlikely to be instantaneous, and the period of time between receiving the injection and death could range over a few minutes to many minutes. Dr. Zivit strongly disagreed with the state's experts' repeated claim that the pentobarbital injection would result in rapid unconsciousness. Dr. Zivit explained that Bucklew would likely experience unconsciousness that sets in progressively as the chemical circulates through his system, and that it was during this period that Bucklew was likely to experience prolonged feelings of suffocation and excruciating pain. The state asked the district court to grant summary judgment in its favor on the theory that Bucklew failed to identify a genuine factual issue regarding whether an execution by lethal injection would be impermissibly painful. The district court refused. The court believed that Bucklew had adequately shown that for up to several minutes he could be aware that he is choking or unable to breathe, but be unable to adjust his breathing to remedy the situation. Recognizing that the state's evidence suggested that Bucklew would experience this choking sensation for a shorter period, the district court concluded that the dispute between the experts was a factual dispute that the court cannot resolve on summary judgment and that would have to be resolved at trial. The district court was right. The evidence taken in light most favorable to Bucklew creates a genuine factual issue as to whether Missouri's lethal injection protocol would subject him to several minutes of severe pain and suffering, during which he would choke and suffocate on his own blood. In my view, executing Bucklew by forcing him to choke on his grossly enlarged uvula and suffocate on his blood would exceed the limits of civilized standards. The experts dispute whether Bucklew's execution will prove as unusually painful as he claims, but resolution of that dispute is a matter of trial. The majority, while characterizing the matter as critical, says that there is nothing in the record to suggest that Mr. Bucklew will be capable of experiencing pain for more than 20 to 30 seconds after being injected with pentobarbital. But what about Dr. Zivit's testimony that the time between injection and death could range over a few minutes to many minutes? What about Dr. Zivit's characterization of the pain involved as prolonged? What about Dr. Zivit's strong disagreement with the state's experts' repeated claim that the pentobarbital injection would result in rapid unconsciousness? The majority construes Dr. Zivit's testimony to show only that Bucklew might remain alive for several minutes after the injection, not that he will be capable of feeling pain for several minutes after the injection. But immediately following his prediction that the time between the injection and death could range up to many minutes, Dr. Zivit stated that, beginning with the injection of the pentobarbital solution and ending with Mr. Bucklew's death several minutes to as long as many minutes later, Mr. Bucklew would be highly likely to experience feelings of air hunger and the excruciating pain of prolonged suffocation. Dr. Zivit thus testified both that lethal injection would take up to several minutes to kill Bucklew and that Bucklew would experience excruciating pain during this period. And it is not the case, as the majority believes, that Dr. Zivit carefully avoided claiming that Mr. Bucklew would be capable of feeling pain until he died, particularly given that the record must be construed in the light most favorable to Bucklew. The majority also justifies its refusal to credit Dr. Zivit's testimony on the ground that Dr. Zivit gave a response during his deposition suggesting that he misinterpreted a study of euthanasia in horses. Bucklew's expert, however, did not rely exclusively or even heavily upon that study. He mentioned it only in response to a question posed in his deposition. To the contrary, Dr. Zivit explained that his testimony regarding the pain to which Bucklew would be subjected was supported by his own professional knowledge of how chemicals of this type are likely to exert their effects in the body, as well as by the terms of Missouri's execution procedure. Whether any mistake about the importance of a single study makes all the difference to Bucklew's case is a matter not for this court to decide at summary judgment, but for the fact finder to resolve at trial. As Judge Colleton pointed out in the dissent below, attacks on the reliability and credibility of Dr. Zivit's opinion, including his possible misreading of the horse study on which he partially relied, give rise to factual disputes. Judge Colleton therefore concluded that the district court did not err in concluding that it could not resolve the dispute between the experts on summary judgment. I agree. This case next presents a legal question. The court in Glossop held in the context of a facial challenge to a state's execution protocol that the plaintiffs were required not only to establish that the execution method gave rise to a demonstrated risk of severe pain, but also to identify a known and available alternative method. The court added that the alternative must be feasible, readily implemented, and in fact significantly reduces substantial risk of severe pain. I joined the dissent in Glossop, but for present purposes I accept the Glossop majority opinion as governing. I nonetheless do not believe its alternative method requirement applies in this case. We often read general language in judicial opinions as referring in context to circumstances similar to the circumstances then before the court, and not referring to quite different circumstances that the court was not then considering. And while I acknowledge that the court in Glossop spoke in unqualified terms, the circumstances in Glossop were indeed different in relevant respects from the circumstances presented here. The plaintiffs in Glossop undertook an across-the-board attack against the use of a particular execution method, which they maintained violated the Eighth Amendment categorically. In this case, by contrast, Bucklew does not attack Missouri's lethal injection protocol categorically, or even in respect to any execution other than his own. Instead, he maintains that he is special, that he suffers from a nearly unique illness, and that by virtue of that illness, Missouri's execution method will be excruciatingly painful for him, even though it would not affect others in the same way. These differences make a difference. First, these differences show that the reasons that underlie Glossop's alternative method requirement do not apply here. The Glossop court stressed the importance of preventing method of execution challenges from becoming a backdoor means to abolish capital punishment in general. The court wrote that because it is settled that capital punishment is constitutional, it necessarily follows that there must be a constitutional means of carrying it out. The court added that we have time and again reaffirmed that capital punishment is not per se constitutional, and the court feared that allowing prisoners to invalidate a state's method of execution without identifying an alternative method would effectively overrule these decisions. But there is no such risk here. Holding Missouri's lethal injection protocol unconstitutional as applied to Bucklew, who has a condition that has been identified in only 5 people, would not risk invalidating the death penalty in Missouri. And because the state would remain free to execute prisoners by other permissible means, declining to extend Glossop's alternative method requirement in this context would be unlikely to exempt Bucklew or any other prisoner from the death penalty. Even in the unlikely event that the state could not identify a permissible alternative in a particular case, it would be perverse to treat that as a reason to execute a prisoner by the method he has shown to involve excessive suffering. The Glossop Court, in adopting the alternative method requirement, relied on the Chief Justice's plurality opinion in Bays, which discussed the need to avoid intruding on the role of state legislatures in implementing their execution procedures. But no such intrusion problems exist in a case like this one. When adopting a method of execution, a state legislature will rarely consider the method's application to an individual who, like Bucklew, suffers from a rare disease. It is impossible to believe that Missouri's legislature, when adopting lethal injection, considered the possibility that it would cause prisoners to choke on their own blood for up to several minutes before they die. Exempting a prisoner from the state's chosen method of execution in these circumstances does not interfere with any legislative judgment. The court in Glossop may have also believed that the identification of a permissible alternative method of execution would provide a reference point to assist in determining how much pain in an execution is too much pain. But there is no need for any such a reference point in a case like this. Bucklew accepts the constitutionality of Missouri's chosen execution method as to prisoners who do not share his medical condition. We are informed that this method has been used in 20 executions, apparently without subjecting prisoners to undue pain. To the extent that any comparator is needed, those executions provide a ready-made, built-in comparator against which a court can measure the degree of excessive pain Bucklew will suffer. Second, precedent counsels against extending Glossop. Neither this court's oldest method of execution case, Wilkerson v. Utah, nor any subsequent decision of this court until Glossop held that prisoners who challenge a state's method of execution must identify an alternative means by which the state may execute them. To the contrary, in Hill v. McDonough of 2006, the court squarely and unanimously rejected the argument that a prisoner must identify an alternative authorized method of execution. The court noted that any such requirement would change the traditional pleading requirements, which we are not at liberty to do. It is thus difficult to see how the alternative method requirement could be compelled by our understanding of the Constitution, even though the Constitution itself never hints at such a requirement, even though we did not apply such a requirement in more than a century of method of execution cases, and even though we unanimously rejected such a requirement in Hill. And while the court in Glossop did not understand itself to be bound by Hill, the two decisions remain in considerable tension. Confining Glossop's alternative method requirement to facial challenges would help to reconcile them. Third, the troubling implications of today's ruling provide the best reason for declining to extend Glossop's alternative method requirement. The majority acknowledges that the Eighth Amendment prohibits states from executing prisoners by horrid modes of torture, such as burning at the stake, but the majority's decision permits a state to execute a prisoner who suffers from a medical condition that would render his execution no less painful. Bucklew has provided evidence of a serious risk that his execution will be excruciating and grotesque. The majority holds that the state may execute him anyway. That decision confirms the warning leveled by the Glossop dissent, that the court has converted the Eighth Amendment's categorical prohibition into a conditional one. Even assuming for argument's sake that Bucklew must bear the burden of showing the existence of a known and available alternative method of execution that significantly reduces a substantial risk of severe pain, Bucklew has satisfied that burden. The record contains more than enough evidence on the point to raise genuine and material factual issues that preclude summary judgment. Bucklew identified as an alternative method of execution the use of nitrogen hypoxia, which is a form of execution by lethal gas. Missouri law permits the use of this method of execution. 3 other states, Alabama, Mississippi, and Oklahoma, have specifically authorized nitrogen hypoxia as a method of execution, and Bucklew introduced into the record reports from Oklahoma and Louisiana indicating that nitrogen hypoxia would be simple and painless. These reports summarize the scientific literature as indicating that there is no reported physical discomfort associated with inhaling pure nitrogen, that the onset of hypoxia is typically so subtle that it is unnoticeable to the subject, and that nitrogen hypoxia would take an estimated 17 to 20 seconds to render a subject unconscious. The Oklahoma study concluded that nitrogen hypoxia is the most humane method of execution available, and the Louisiana study stated that the use of nitrogen as a method of execution can assure a quick and painless death of the offender. How can the majority conclude that Bucklew has failed to identify an alternative method of execution? The majority finds Bucklew's evidence inadequate in part because, in the majority's view, it does not show that nitrogen hypoxia will significantly reduce Bucklew's risk of pain as compared with lethal injection. But the majority does not dispute the evidence suggesting that nitrogen hypoxia would be quick and painless and would take effect in 20 to 30 seconds. The majority instead believes that nothing in the records suggests that lethal injection would take longer than nitrogen gas to take effect. As I have already explained, the majority reaches this conclusion by overlooking considerable evidence to the contrary, such as Dr. Zivit's testimony that Bucklew's pain would likely prove prolonged, that lethal injection would not result in rapid unconsciousness, and that from the time of injection to Mr. Bucklew's death, several minutes to as long as many minutes later, Mr. Bucklew would be highly likely to experience the excruciating pain of prolonged suffocation. In discounting this evidence, the majority simply fails to adhere to the axiom that in ruling on a motion for summary judgment, the evidence of the non-movement is to be believed, and all justifiable inferences are to be drawn in his favor. The majority additionally believes that Bucklew's evidence fails to show that nitrogen hypoxia would be easy to implement. But the reports from Oklahoma and Louisiana tell a different story. The Louisiana report states that nitrogen hypoxia would be simple to administer. The Oklahoma report similarly concludes that death sentences carried out by nitrogen inhalation would be simple to administer. The reports explain that nitrogen hypoxia would not require the use of a complex medical procedure or pharmaceutical products, would not require the assistance of licensed medical professionals, and would require only materials that are readily available for purchase. Further, because the protocol involved in nitrogen-induced hypoxia is so simple, mistakes are unlikely to occur, and both sides recommend the development of protocol for actual implementation. Presented with evidence such as Bucklew's, I believe a state should take at least minimal steps to determine the feasibility of that proposed alternative. The responsible state official in this case, however, acknowledged that he did not conduct research concerning the feasibility of lethal gas as a method of execution in Missouri. The majority sensibly recognizes that an inmate seeking to identify an alternative method of execution is not limited to choosing among those presently authorized by a particular state's law, but the majority faults Bucklew for failing to provide guidance about the administration of nitrogen hypoxia down to the last detail. The majority believes that Bucklew failed to present evidence on essential questions such as whether the nitrogen should be administered using a gas chamber, a tent, a hood, or a mask, or in what concentration, pure nitrogen or some mixture, it should be administered, or even how the state might protect the execution team against the risk of gas leaks. Perhaps Bucklew did not provide these details, but Glossop did not refer to any of these requirements. Today's majority invents them, and to insist upon them is to create what, in a case like this one, would amount to an insurmountable hurdle for prisoners like Bucklew. That hurdle, I fear, could permit states to execute even those who will endure the most serious pain and suffering, irrespective of how exceptional their case and irrespective of how thoroughly they prove it. I cannot reconcile the majority's decisions with a constitutional amendment that forbids all cruel and unusual punishments. Justice Thomas concurs in the majority's imposition of an alternative method requirement, but would also permit Bucklew's execution on the theory that a method of execution violates the Eighth Amendment only if it is deliberately designed to inflict pain. But that is not the proper standard. For one thing, Justice Thomas's view would make the constitutionality of a particular execution turn on the intent of the person inflicting it, but it is not correct that conceitedly torturous methods of execution such as burning alive are impermissible when imposed to inflict pain, but not when imposed for a subjectively different purpose. To the prisoner who faces the prospect of a torturous execution, the intent of the person inflicting the punishment makes no difference. For another thing, we have repeatedly held that the Eighth Amendment is not a static prohibition that prescribes the same things that it prescribed in the 18th century. Rather, it forbids punishments that would be considered cruel and unusual today. The amendment prohibits unnecessary suffering in the infliction of punishment, which this court has understood to prohibit punishments that are grossly disproportionate to the severity of the crime, as well as punishments that do not serve any penological purpose. The Constitution prohibits gruesome punishments, even though they may have been common at the time of the founding. Few would dispute, for example, the unconstitutionality of a new law providing public lashing or branding of the right hand as punishment, even if it could be demonstrated unequivocally that these were not cruel and unusual measures in 1791. The question is not, as Justice Thomas maintains, whether a punishment is deliberately inflicted to cause unnecessary pain, but rather whether we would today consider the punishment to cause excessive suffering. Now we get to part 3 of Breyer's dissent. So this is where it's just Breyer. At this point, Kagan, Ginsburg, and Sotomayor have dropped out of the third part, and they said, we don't necessarily agree with this part of your dissent. But he says, implicitly at the beginning of its opinion and explicitly at the end, the majority invokes the long delays that now typically occur between the time an offender is sentenced to death and his execution. Bucklew was arrested for a crime that led to his death sentence more than 20 years ago, and Bucklew's case is not an anomaly. The average time between sentencing and execution approaches 18 years and in some instances rises to more than 40 years. I agree with the majority that these delays are excessive. Undue delays in the death penalty cases frustrate the interests of the state and of surviving victims, who have an important interest in seeing justice done quickly. Delays also exacerbate the suffering that accompanies an execution itself. Delays can aggravate the cruelty of capital punishment by subjecting the offender to years in solitary confinement, and delays also undermine capital punishment's jurisprudential rationale by reducing its deterrent effect and retributive value. The majority responds to these delays by curtailing the constitutional guarantees afforded to prisoners like Bucklew, who have been sentenced to death. By adopting elaborate new rules regarding the need to show an alternative method of execution, the majority places unwarranted obstacles in the path of prisoners who assert that an execution would subject them to cruel and unusual punishment. These obstacles in turn give rise to an unacceptable risk that Bucklew or others in yet more difficult circumstances may be executed in violation of the Eighth Amendment. Given the rarity with which cases like this one will arise, an unfortunate irony of today's decision is that the majority's new rules are not even likely to improve the problems of delay at which they are directed. In support of the need to end delays in capital cases, the majority refers to Dunn v. Ray. In that case, the court vacated a stay of execution on the ground that the prisoner brought his claim too late. The prisoner in that case, however, brought his claim only 5 days after he was notified of the policy he sought to challenge. And in the view of some of us, the prisoner's claim that prisoners of some faiths were entitled to have a minister present at their executions, while prisoners of other faiths were not, raised a serious constitutional question. And therein lies the problem. It might be possible to end delays by limiting constitutional protections for prisoners on death row, but to do so would require us to pay too high a constitutional price. Today's majority appears to believe that because the Constitution allows capital punishment, the Constitution must allow capital punishment to occur quickly. In reaching that conclusion, the majority echoes an argument expressed by the court in Glossip, namely that because it is settled that capital punishment is constitutional, it necessarily follows that there must be a constitutional means of carrying it out. These conclusions do not follow. It may be that there is no way to execute a prisoner quickly while affording him the protections that our Constitution guarantees to those who have been singled out for our law's most severe sanction. And it may be that as our nation comes to place ever greater importance upon ensuring that we accurately identify, through procedurally fair methods, those who may lawfully be put to death, there simply is no constitutional way to implement the death penalty. I have elsewhere written about these problems, and I simply conclude here that the law entitles Bucklew to an opportunity to prove his claim at trial. I note, however, that this case adds to the mounting evidence that we can either have a death penalty that avoids excessive delays and arguably serves legitimate penological purposes, or we can have a death penalty that seeks reliability and fairness in the death penalty's application and avoids the infliction of cruel and unusual punishments. It may well be that we cannot have both. I respectfully dissent. So essentially, Breyer was given the same evidence as the other judges, he heard the same oral arguments as the other judges, and yet he still came to a different conclusion, which I think is one of the most interesting facets of the Supreme Court and of law in general. He's basically saying, well, Bucklew's throat tumor is going to rupture, he's going to feel as though he's drowning alive for many minutes, and that, for me, is cruel and unusual. The other thing he hits home on is, throughout the majority and concurring opinions, there was this talk about delays in death penalty, delays in carrying out the death penalty, and its constitutionality. And we heard Gorsuch say that that's between the people and their representatives, and it's not for the court to decide. Well, now you have Breyer saying, well, if we can't have a death penalty that is not cruel, or if we can't have a death penalty that is quick, it's not constantly being challenged and moving through the courts, then maybe we shouldn't have one at all. So moving on, we have the last dissent from Justice Sotomayor, who says, "As I have maintained ever since the court started down this wayward path in Glossop v. Gross, There is no sound basis in the Constitution for requiring condemned inmates to identify an available means for their own executions. Justice Breyer ably explains why today's extension of Glossop's alternative method requirement is misguided, even on that precedent's own terms, and why, with or without that requirement, a trial is needed to determine whether Missouri's planned means of executing Russell Bucklew creates an intolerable risk of suffering in light of his rare medical condition. I join Justice Breyer's dissent, except for Part 4. I write separately to address the troubling dicta with which the court concludes its opinion. Given the majority's ominous words about late arising death penalty litigation, one might assume there is some legal question before us concerning delay. Make no mistake, there is not. The majority's commentary on once and future stay applications is not only inessential but also wholly irrelevant to its resolution of any issue before us. The majority seems to imply that this litigation has been no more than manipulation of the judicial process for the purpose of delaying Bucklew's execution. When Bucklew commenced this case, however, there is nothing settled about whether the interaction of Missouri's lethal injection protocol and his rare medical condition would be tolerable under the Eighth Amendment. At that time, Glossop had not yet been decided, much less extended to any as-applied challenge like Bucklew's. In granting prior stay requests in this case, we acted as necessary to ensure sufficient time for sober review of Bucklew's claims. The majority laments those decisions, but there is nothing unusual, and certainly nothing untoward, about parties pressing and courts giving full consideration to potentially meritorious constitutional claims, even though those claims do not ultimately succeed. I am especially troubled by the majority's statement that last-minute stays should be the extreme exception, which could be read to intimate that late-occurring state requests from capital prisoners should be reviewed with an exceptionally jaundiced eye. Were those comments to be mistaken for a new governing standard, that would affect a radical reinvention of established law and the judicial role. Courts' equitable discretion in handling stay requests is governed by well-established principles. Courts examine the stay applicant's likelihood of success on other merits, whether the applicant will suffer irreparable injury without a stay, whether other parties will suffer substantial injury from a stay, and public interest considerations. It is equally well established that death is a punishment from all other sanctions in kind rather than degree. For that reason, the equities in a death penalty case will almost always favor the prisoner so long as he or she can show a reasonable probability of success on the merits. This accords with each court's duty to search for constitutional error with painstaking care in capital cases. It is of course true that a court may deny relief when a party has unnecessarily delayed seeking it, and that courts should not grant equitable relief on clearly dilatory, speculative, or meritless grounds. That is hardly the same thing as treating late arising claims as presumptively suspect. The principles of federalism and finality that the majority invokes are already amply served by other constraints on our review of state judgments, most notably the Anti-Terrorism and Effective Death Penalty Act of 1996, but also statutes of limitations and other standard filters for dilatory claims. We should not impose further constraints on judicial discretion in this area based on little more than our own policy impulses. Finality and federalism need no extra thumb on the scale from this court, least of all with a human life at stake. The only sound approach is for courts to continue to afford each request for equitable relief a careful hearing on its own merits. That responsibility is never graver than when the litigation concerns an impending execution. Meritorious claims can and do come to light even at the 11th hour, and the cost of cursory review in such cases would be unacceptably high. A delay, moreover, may be entirely beyond a prisoner's control. Execution methods, for example, have been moving targets subject to considerable secrecy in recent years, which means that constitutional concerns may surface only once a state settles on a procedure and communicates its choice to the prisoner. In other contexts, too, fortuity or the imminence of an execution may shake loose constitutionally significant information when time is short. There are higher values than ensuring that executions run on time. If a death sentence or the manner in which it is carried out violates the Constitution, that stain can never come out. Our jurisprudence must remain one of vigilance and care, not one of dismissiveness. So that was the end of Justice Sotomayor's dissent, and to me at least, it seems as though the dissenting side of the court is looking at Bucklew through the perspective of, this guy has been found guilty of these horrible crimes, but he's still a person, and he's still afforded the same rights and liberties as any other citizen. And you can see this in the dissenting opinion. The justices are using more empathic diction they discussed that humanity and morality of execution, whereas the plurality of justices seem to be looking at this from purely a legal standpoint. And you can see in Justice Sotomayor's dissent especially, you can see she really emphasizes the point that it doesn't matter how long the delays in an execution are. She says, first of all, the delays in an execution isn't even a question that this court is answering in this case. So we shouldn't even be talking about that because we might accidentally be creating precedent and reinventing how we look at death penalty cases. The other thing she says is even if there are like extensive delays in an execution, it's worth it to know that at least the prisoner won't be feeling excruciating pain, because like she says, if you execute a person and they do experience excruciating pain, let's say Bucklew does choke on his own blood, that's a stain on the history of capital punishment that can never come out. So she's saying it's worth it to take the extra time and go through the hoops kind of to make sure that all death row inmates are afforded the same protections as everybody else. So you can see this differs from the majority opinion because they're looking at Bucklew as kind of a legal entity, and they're also keeping the interests of the state in mind a lot with this. You can see that Breyer and Sotomayor kind of had an attitude of, well, it doesn't matter, or at least Breyer didn't have this attitude, but Sotomayor had this attitude of, it doesn't matter how long the execution takes, we just have to make sure that the prisoners aren't undergoing excruciating pain. You can see that in the majority opinion. They don't really agree with that. They have the interests of the state in mind and saying, they have the interests of the state and the victims' families and relatives and friends and things like that in mind. They're saying, you can't have these executions, being pushed back, postponed for 20-odd years because the state has a compelling interest to carry out the sentence. The families and the family and friends of the victims have an interest to see that the execution is carried out to finally get some sense of justice, some sense of closure. Sotomayor kind of dismisses that idea and says, no, the Eighth Amendment comes first. We have to make sure that's coming first. How you see this case, though, that's up to you, but I would like to know what you think, so let me hear your opinions in the comments. So, what happens now and what has happened to all the people involved? Well, first off, this case sets a precedent that a death row inmate with a rare medical condition is not necessarily able to avoid execution under the Eighth Amendment. They still have to pass the Bayes-Glossop test. As for Bucklew, he's officially out of options, so sometime in the near future he will be injected with pentobarbital, and perhaps we might hear on the news of a boxed execution in Missouri, or perhaps we hear nothing if the execution goes according to plan. That's if Missouri sticks to pentobarbital. Of course, if they switch to a new method, you can kind of be sure that Bucklew's going to raise hell in the courts over that. As for Stephanie Ray, she met an untimely fate several years ago that was bizarrely similar to her interactions with Mr. Bucklew. After her relationship with Bucklew ended and after Michael Sanders was killed, she married a man named John Shuffett. Some years later, the two divorced, and some years after that, Stephanie, who now kept the last name of Shuffett, was fixing her lawnmower when her ex-husband approached her with his rifle, shooting and slaying the woman. An unfortunate end, to be sure. I don't really know how to transition from that to the outro, but if you did enjoy this episode or know somebody who might sharing this podcast, liking it, subscribing, following, whatever you may, would be greatly appreciated. I've included links to the sources for this episode in the description, and I highly recommend you check those out if you like this. You can read more information or hear the oral arguments in their entirety, which I found very fascinating. More episodes will be coming soon. In fact, I do plan to take a look at the Bayes v. Rees and Glossop v. Gross cases sometime in the future. Until then, I'll gladly take suggestions on cases you want to see talked about, or maybe if you want a certain topic talked about, such as First Amendment cases, Third Amendment cases, or any other issues in the modern political sphere, or in the political sphere in general. I'm sure I can find a Supreme Court case that deals with that. Anyways, I don't really know what else to say. Other than that, I will be working on getting this podcast on more platforms in the future, and I thank you for listening. Goodbye.